Are you Mr. Chapman?
Yes.
All right, so we'll call from page 4, the case of People of the State of Michigan versus Wyatt Chapman. It's file 20-93165FH. And we have Mr. Chapman present with us from the Michigan Department of Corrections by Zoom video. His attorney, Mr. Gilbert's present in the courtroom, as is the prosecuting attorney, Mr. Radzaban. We're providing public access both in the courtroom and online. And Mr. Chapman, you would have the right to be physically present in the courtroom for your sentencing. Do you wish to exercise that right, or would you like to waive it and be sentenced on video here today?
Right away, this is a critical legal moment. By waiving his right to appear in person, Chapman is allowing the sentencing to move forward via video from the Michigan Department of Corrections. That might seem routine, but in courtroom psychology, physical presence can sometimes humanize a defendant. Do you think appearing in person could have influenced the judge's perception, or was the outcome already leaning a certain way?
To waive it, Your Honor.
All right, and have you had a chance to review the pre-sentence recommendations with Mr. Gilbert?
Yes.
All right, Mr. Gilbert, do you have any additions or corrections to the information contained in that report?
Your Honor, I did discuss this with my client. I was able to get it to him, and him and I did talk via telephone. We have no additions or corrections, Your Honor.
Okay, Mr. Radzaban, any additions or corrections?
No additions or corrections, Judge.
Okay, the advisory guidelines range is scored at 10 to 23 months. Any scoring challenges, Mr. Gilbert?
Your Honor, I reviewed that, and I have no challenges to the scoring.
Mr. Radzaban?
No challenges to the scoring, Judge.
Hey, Mr. Gilbert, anything you'd like to say on behalf of your client?
Yes, I didn't mean to say I meant to say, Your Honor, we did have a agreement in this case, I believe, to a 6-month jail sentence, and in light of my client's situation, we don't want to adhere to that. We'd ask the court to consider a prison recommendation. The reason for that, then that would remove any option. I mean, that's what he'd be sentenced to because he was on parole at the time of this offense. I would point out, though, that I do believe he has some comments for the court. I would point out, though, MDOC picked him up in February. I believe it was February 8th. Prior to that, he sat in the county jail since fall. With the COVID lockdown, that did not work well for my client. I believe he's approaching 8 or 9 months of incarceration already. We'd ask the court to take a middle range of the guidelines and possibly consider 15 months. I'm hoping that he does get credit from February when he was taken into MDOC. Thank you very much, Your Honor.
Thank you, Mr. Gilbert. Mr. Chapman, is there anything that you wish to say, sir?
Yes, Your Honor.
This is the emotional core of the hearing. The defendant is trying to shift from case file to human story. Notice the strategy: acknowledgement of wrongdoing, personal trauma, and future goals. In sentencing hearings, judges often look for 3 things: accountability, rehabilitation potential, and risk to the public. The big question is, does this sound like genuine remorse, or does the court see a pattern tied to his prior record?
I'm here today because I made a mistake and I accept full responsibility for my wrongdoings. But I'm much more than you see on paper. I'm not a meth dealer or a meth user. I had enough ecstasy for one-time use. Ecstasy can only be used at most once a month to feel the full effects, which last 6 hours. I'm not justifying my use, just saying there's a big difference between the two, and I wasn't out using meth, binging for days or weeks like so many others. It is an evil drug that is ruining the world along with countless lives. But I was wrong, and I wish I could take it back. I've struggled with different substances for a long time. I've come a long way from daily opiate dependence and haven't used opiates in over 3 years. I battle with depression, anxiety, and PTSD. I'm still learning to cope. My family and I have experienced much trauma and loss. My brother passed away in 2017. My younger brother. My daughter's mother, who was a meth addict, took her away from us out to North Dakota, cutting us off from all contact, telling us we will never see her again. I'm legally powerless and at her mother's mercy because she was born under wedlock to a man who committed suicide and can no longer sign her rights over to me. She used my love for my daughter against me for 6 years, and all this has taken a serious toll on my mental health. We miss my little girl and her little sister dearly and fear for them every day. We've been there for them through so much. I'm a good dad and my kids absolutely adore me. My son, who is so used to having me around, misses me and constantly talks about me. I cannot even express how much it hurts having my girl ripped away and being locked away from my boy for so long when all I want is to be a father, protect them, and be a part of these precious years. They're so beautiful and intelligent. They mean the world to me and I miss them terribly. They need their dad. I'm turning my life around. There are so many people who believe in me. I'm fortunate to have such a big family out there waiting for me to come home and enjoy life with them. It's very hard to know I've let them down, and I'll never allow this to happen again. They deserve better. I'm not a drain on society. I'm a hard worker who's always held down a job. Cooking is my passion, and I would like to someday open my own restaurant. I have productive hobbies to spend my time doing with my family, like gardening, raising livestock, and fishing. I will find a good counselor who can help me work through and understand my addictions and anger. That night wouldn't have happened the way it did if it wasn't for my alcohol abuse. My failures are a direct result of my addictions. I'm ready to put this all behind me and move on. I'm so tired of suffering and letting these things control me, and I will utilize all the help I can get. I know I can do better. I'm a good person with a good heart. I'm genuinely sorry for what I've done to my kids, my family, the community, the court, and to Madison. Violence is completely out of character for me, and I feel so ashamed and truly remorseful for my actions. I'm going to keep working on myself, continue my recovery, abide by the law, and avoid anything that could risk my freedom and success. Since I'm not yet sentenced for my parole violations, and getting sentenced to a prison term today would make my violations go away, I'm told it's therefore possible to get credit for the 5 months I've been in the MDOC. So today I would ask that you please consider the 9 months I've already been incarcerated and give me a lighter sentence in the MDOC. Life's too short and I just want to go home and start over. This is the hardest and longest time I've done, and honestly, I've learned my lesson. It's changed my whole demeanor and outlook on life, and I'll never be the same or forget this awful experience. I know what I must do differently, and I'm done with my old ways.
Thank you, Mr. Chap.
Thank
Mr.
you.
Radsbon, recommendations from the people?
Your Honor, we did agree to a 6-month county cap. And we will hold to that. Of course, it would be consecutive to when he is released from prison on his current term. But we'll leave that up to the court's discretion.
Okay, thank you, Mr. Radsbon. Well, Mr. Chapman, any sentence I give today is required to be mandatory to any sanction on the parole violation. You were on parole at the time of this offense. I hope that, it sounds like you understand that, you're being sentenced today for.
Here's where the legal weight really hits. Prior felonies and committing a new offense while on parole dramatically change sentencing dynamics. Even though the guideline range was relatively moderate, parole status often pushes judges towards stricter penalties because it signals prior interventions didn't work. Watch closely. This is the turning point where the sentence is about to move beyond the original plea agreement.
Possession of a dangerous drug. And I hope you understand that it's a lot more than just possessing and using a drug that gives you some euphoria or some energy or some reaction in your brain that you desire. It causes you to act in ways that now you are ashamed of, that you acted violently toward people that you care about and uncooperatively to the police. And that's not, sounds like that's not who you want to be. So I hope that you draw the right lessons from that perhaps these drugs are not helpful to the life you want to live. You want to enjoy time with your family. You want to pursue your culinary passions. Illegal drug use is not going to help you do any of those things. You've got 4 prior felonies. You were on parole at the time. So I'm not going to follow the sentence agreement for the 6-month county cap. I would sentence you to 15 months minimum in the Michigan Department of Corrections would be my intention. Mr. Gilbert, you've had a chance to review that with Mr. Chapman. Does he wish to withdraw the plea or go forward with that sentence?
We would go forward with that sentence. Thank you, Your Honor.
All right, so Mr. Chapman, you understand because I'm not following the plea agreement, you would have the right to withdraw that plea. I'm supposed to tell you what my sentence would be to allow you to decide. So my sentence would be, if you want to go forward, the Michigan Department of Corrections for 15 months to 10 years with no credit because it's consecutive to parole. Do you wish to withdraw your plea or go forward with the sentence?
I wish to go forward with the sentence, Your Honor.
All right, Mr. Chapman. Well, taking all those things into account, it would be the sentence of this court that you would be committed to the custody of the Michigan Department of Corrections for a term of not less than 15 months nor more than 10 years. There's credit for 0 days served because it's mandatory to parole. And there's state costs of $68 and crime victims rights assessment of $130. And Mr. Chapman, if you wish to appeal, you'd have to file an application for leave to appeal. If you couldn't afford an attorney, we would appoint one for you at public expense if you make that request within 42 days of today's date. So we're going to send you a copy of those appeal rights and ask you to initial one for return to us so we have it in the file that we know you have those rights. The other one is for you to fill out if you do wish to appeal. This is a sentence within the guidelines, and I do understand if the DOC decides not to impose a prison penalty on the parole violation, perhaps you'll end up getting some credit on this, but this will be mandatory consecutive to whatever they do. All right, any questions, Mr. Chapman?
No, Your Honor.
Okay, good luck to you, sir.
Thank you very much. Good luck, Mr. Chapman.
Thank you, Mr. Gilbert.
Clear County Jail.
Okay.
George was released June 18th, I believe, from there. I know we sent notice of the arraignment and the information to an address in Mount Pleasant. In addition to
We rose to or ever come to know.
we also sent it to the Clear County Jail, so it could be, maybe she's been, she had something outstanding in Midland, but my understanding was that was a 14-day thing that should be over with by now. So,
Okay. All right, well, we're here for an initial arraignment on that case. Lucas 21-93173FH. It's scheduled for 9 a.m. We have the complaining witness in the Zoom meeting. We were allowing Ms. Lucas to report by Zoom. Counsel reports that she was in another county's jail. Reportedly, she's been released and he hasn't had contact with her. This is the first non-appearance in this file since it's the initial arraignment. Mr. Radzaban, any request from the people?
yes, Judge, I'd ask that the bond be canceled and potential would be issued for her arrest.
All right, well, I might be inclined to do that, but I think the new criminal justice reforms would prevent me from doing so. This being the first failure to appear in the case.
In this court, it's the first, it's not her first failure to appear.
In this case, in the
No,
district court?
In other counties.
Sure, yeah, the way the law says it's in the case. So what I can do is, we're back here on August 2nd. What I'll do is we'll do a show cause for August 2nd and continue the arraignment to that date. For 9:10 a.m. And we'll require her to appear in person. If she doesn't appear at that date and time, we'll issue a warrant. Mr. Radsbon, is your office able to prepare a affidavit for show
I'll have
cause?
them do that. and
Okay,
Get you to sign.
okay, thank you. All right, Mr. James, sorry, Ms. Lucas isn't here today, so we're gonna give her until the next court date, August 2nd, to appear and explain why she wasn't here today. If she's not here, then we'll issue a warrant for her arrest. Okay. All right, have a good day, sir.